All right, Mr. Casanova, you want to come forward? Yes. Hello, how's it going?
Could be better.
All right, so my understanding, you want to represent yourself? All right, you're more than welcome to represent yourself, but here's the thing. Everybody says that they can be an attorney because all attorneys do is talk. That's what people think. But they don't realize there's a lot of knowledge, experience, and wisdom behind that.
Absolutely.
So if you want to have a jury trial where you represent yourself, you're more than welcome to do so. But once it's set for trial, it's going to trial, and no one's going to be helping you. The state is not going to say, hey, we see that you really don't know the rules, so let me tell you this rule. They're not going to be doing that. My job is not going to be to help you with objections, help you with motions. That's 100% you. Do you understand?
I do. And are we on the record?
No, we're not on the record. What, you want to put something on the record?
Oh, yes, definitely.
Sure. All right, court is calling 2024 CR 2974, State of Texas Vector versus Hector Casanova. Can I have parties announced for the record for the state? And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there. I just have a few questions to clarify some things.
All right, so if you would like to clarify some things, then the person I need to speak to is the flesh and blood man known as Hector Casanova.
Welcome back to the channel, everyone. Today's case dives deep into the fascinating and sometimes frustrating world of sovereign citizen logic. Our defendant, Minister Hector Casanova Jr., insists is not the legal fiction listed on the indictment. He claims to be a flesh and blood man appearing under special appearance, a classic sovereign tactic used to deny court jurisdiction. But judge in this case, calm, patient, and razor sharp. You're about to see how she methodically dissects every attempt to derail the process. What starts as a routine advisement hearing quickly spirals into a legal tug-of-war over identity, jurisdiction, and constitutional misunderstandings. But beneath the confusion, one thing stands out: the judge's ability to maintain control, clarity, and even humor in the face of chaos. Stick around, because this case isn't just about law. It's a masterclass in courtroom composure versus self-made chaos. Let's dive in.
Yes, I'm the flesh and blood man, Hector Casanova Jr.
All right, so you are Hector Casanova, correct?
I am Hector Casanova Jr., the flesh and breathing man.
All right, well, I'm glad you're breathing. So what did you want to place on the record?
Well, first, I don't understand the charges that are being brought against me. There are some clarifications I do want to.
All right, so just 1 second, but before we get to that, have you been given a copy of the indictment?
No, I have not.
All right, so we're going to get you a copy of the indictment. Just give me a moment. All right, have a seat. We're going to come back on the record with this.
All right.
Deputy Laura, do you know if he's been served with the indictment yet?
I'm not sure.
All right, thank you. So we're back on the record in 2024 CR 2974.
And here we go. The moment Mr. Casanova declares he's not the legal fiction. This is a textbook example of sovereign citizen wordplay. By separating the legal name from the living man, they tried to sidestep legal accountability, as if grammar could grant immunity. But courts have heard this for decades, and judges know the script by heart. Notice how the judge immediately ground the conversation. Then the person I need to speak to is the flesh and blood man known as Hector Casanova. It's calm, direct, and effectively resets control of the courtroom without escalating conflict. That's how you dismantle pseudo-legal arguments with clarity and composure.
State versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly, right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for.
Yes, ma'am.
So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
Oh, what that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness. You need surgery and you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm going to go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert by yourself. You don't get to call the doctor and say, hey, I'm in the middle of the desert performing surgery.
This exchange highlights one of the biggest challenges judges face with self-represented defendants, understanding versus misunderstanding. When the judge asks if he's received the indictment, Casanova says no, and even after receiving it, he insists he doesn't understand. What he's really signaling is not confusion about the document, but refusal to accept the court's authority. The judge's analogy comparing self-representation to performing surgery on yourself is brilliant. It cuts through the pseudo-legal fog and gets to the core issue. You can't claim expertise while refusing the tools of expertise. She's not mocking him. She's warning him. But he's too caught up in his ideology to hear it.
I'm going to be my own anesthesiologist. I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you, oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney. After you speak to that attorney, we're going to go forward. Ms. Ferguson, can you call manage to sign counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right. Well, I don't know how I can further make you understand.
Are we on the record?
Yeah. All right. Norma, get someone from manage to sign counsel here, please. All right. Just have a seat and we're going to have an attorney come down. All right.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no. Let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from manage to sign counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr.
At this point, the judge has exhausted every avenue of explanation. When a defendant repeatedly claims, "I do not understand," it triggers a duty of the court to ensure they have proper counsel, not to debate them endlessly. That's why she calls for managed assigned counsel to step in. This move isn't about silencing his rights, it's about protecting them. A judge has to make sure the defendant's due process is preserved, even when the defendant doesn't cooperate. And yet, Casanova still insists is not needing an attorney. This tension between personal ideology and legal reality defines nearly every sovereign citizen courtroom encounter.
Let's see. All right. So let the record of the court show that I, Hector Casanova
Just one
Jr.
second.
The accused
Just
in
one
the-
stop.
Yes, sir.
All right. We're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action.
All right, and
Furthermore,
let me
let the
stop you.
record also show.
Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so, yeah.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment, and the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court, and this is a criminal court.
Okay. So, this being a criminal, let the record of the court show that the action against me is criminal action.
Here comes the hallmark of sovereign ideology, the jurisdictional rabbit hole. Casanova asks whether this is common law or admiralty law. To him, this distinction is everything. To the legal system, it's nonsense. Admiralty jurisdiction deals with maritime issues, ships, oceans, and navigation, not felony charges in Texas. The judge's response, "You're in a criminal court on the 4th floor," is both hilarious and surgical. She refuses to play semantics and brings him right back to reality. It's a subtle power move. She answers the question without entertaining the pseudo-legal trap behind it.
My following question would be, the Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from Managed Assigned Counsel is going to come over, and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent.
Mhm.
I have the right to appear as myself to my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under.
Mhm.
Let's see. So therefore, will you please answer the question so that way this court is properly identified?
All right, you're in the 187 District Court. It's a criminal court. You're on the 4th floor.
Thank you. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under
All right, I'm going
admiralty or military
to counsel.
tribunal.
I'm sorry, Mr. Casanova, in the human flesh. I'm going to stop you right there. What is going to end up happening, I want you to hear me clearly. An attorney is coming over for Managed Assigned Counsel, period. That's it. So have a seat. Managed Assigned Counsel will come over. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right. So take a seat. Thank you. Yes.
We have talked.
Mhm.
I've informed him that I'm here, to help him in whatever he needs help with.
Mhm.
He's going to consider what help he thinks he might need from me, and I know he wants to put something on the record.
Okay. All right. And so you'll be appointed.
You can feel the shift here, patience turning to firmness. The judge interrupts mid-sentence, signaling she's done letting him control the narrative. Her tone remains professional, but her words, period. That's it. So have a seat. Mark the turning point. Judges aren't obligated to indulge circular arguments forever. This is where judicial authority meets its limit of tolerance. What's remarkable, though, is how she still preserves order. No yelling, no threats, just structure. And that's why she maintains credibility where the defendant loses it.
Stand by
Yes.
counsel then.
I've kind of explained my role and what that means and how I can help him with something as simple as e-filing or that type of thing. So,
All right. We're going to go back on the record in 2024 CR 2974, State versus Hector Casanova. Mr. Casanova, if you'll come forward. Yes.
Does that make sense?
All right. So, Mr. Casanova, Mr. Bach is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right.
Uh,
And he informed me you wanted to place something on the record?
yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right. Who threatened or coerced you to come to court?
The county of Bear, Texas.
How so?
Well, if I don't come here, then
Now this is where the theatrics peak. Casanova claims his appearing under threat, duress, and coercion. He argues that attending court voluntarily is equivalent to being kidnapped by the county. That's not just legally wrong, it's a distortion of basic civic responsibility. But watch how the judge handles it. No outrage, no lecture, just logical follow-up. Who threatened or coerced you? She forces him to explain the absurdity of his own claim. By doing that, she transforms his rhetoric into evidence of misunderstanding rather than rebellion. And that's how professionals dismantle pseudo-legal drama, calmly and by the book.